We're running just a little bit ahead of schedule for our next case this morning, scheduled for 11 o'clock, which is Irene Chlebowski versus Nicholas Roth. But are all parties in counsel we're expecting today present here in the courtroom right now?
Yes. Yes.
If you're ready to proceed, we are ready to proceed as you are. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve any time for rebuttal, I am keeping the clock this morning and can keep you apprised of the passage of time. We've read the briefs and we're ready to proceed when you are.
May it please the court. My name is Cedric Cole and I represent the appellant in this case, Irene Chleboski. This matter involves a divorce that was pending in Summit County Domestic Relations Court. The primary issues that I've raised in this case are three. They all essentially involve or address the primary residential parent or custody of the party's minor child, who at the time of this divorce was a toddler. He's approximately 3 years old now. To begin with, I would like to ask the court, I know that we have a very high burden here. I think in this case, everything is that I've cited in my brief and argued in my brief is supported by the record. I asked the court to examine the record very carefully, because this matter is very important to my client. The first issue I raised regards to the constitutional provision of part of Section 3109.4. And throughout my brief, I referred to that as a friendly period concept. And I asked the court to examine that issue in the context of the other two issues. Because when you examine that, one of the things that I talk about in my brief is how that particular issue, particular version, in the context of a custody battle, and particularly in this case when we're talking about the mother who is alleged to have been abused by the father, has alleged that the father has the property taking care of the child, that provision was used in this particular case to punish the mother.
Can I stop you for just a moment?
Excuse me, Mr.
Coleman. In terms of the constitutional argument, it's not clear from the record whether the Attorney General of the state was served in terms of the constitutional provision. So I'm wondering whether or not we are going to be able to consider that on the merits.
Well, I noticed that the appellate did raise that in his brief, and if you examine the statute he cites, it talks about declaratory judgments. I don't believe that that statute applies in individual cases, particularly this case. That statute applies when you challenge the constitutionality of a statute. We weren't challenging the constitutionality of the statute, we were challenging the application of a particular provision of a statute. In other words, the factor that the court to consider in allocating parental rights. It's no different from a suppression motion that applies to a particular case. You're not challenging the constitutionality of statutes. Should this be applied in this case? Is it constitutional to apply this case, that provision, particular provision, in this case, based on the facts alleged in this case? And we're talking about a custody matter. There's no different from challenging the constitutionality of a Miranda warrant. You're not saying the entire statute is unconstitutional. Do not apply this particular factor in this case, based on the facts of this case, would render that provision, that factor, I'll say factor, because the statute talks about the court considering a number of factors. Do not apply that in this case, because here's a mother who's alleging she's been abused by the potential ex-husband, who's trying to protect herself, she's trying to protect her father. And make no mistake, this is a custody battle. I mean, we talk about allocation of rights all the time, but essentially this case is a custody battle. And the statute says that you're supposed to be friendly in that context. That's essentially what that issue goes to. Now, I will point out one thing, that when going back and looking at the record, I realized that the motion was filed the trial court never actually granted or denied the motion or even considered the motion.
Which motion are you referring to?
The motion to challenge the constitutionality of that particular subsection, I'll say subsection or factor in the statute. Based on that, I think the appropriate outcome is to remand that and let at least that issue and let the trial court consider that first in the context of this case. I don't want the court to get the impression that I'm saying the statute is unconstitutional in general.
Well, your
application
of error says 310904F1F and I is unconstitutional because it violates the substantive due process clause of the 14th Amendment. So that, it doesn't even talk about as applied to this individual in the assignment of error. So that's why
well, yeah, the general heading, but as I go through, I talk about primary in the context of an abused parent and how the provision can actually be used to punish a mother. It deters victims of domestic violence from speaking out. It's viewed under that particular factor. Any allegations of abuse are taken as mere conflict. And I think that's what happened in this case. You'll notice that in my other articles talk about in terms of, and I think all these issues kind of tie together because again, you're talking about, as applied to this case, ultimately in this case, the mother was the primary caretaker from birth of this child. The father abandoned the marital home. There was documented that he was a father who had a history of violence towards women. He was charged with burglary from an incident arising where he allegedly broke into someone's house and damaged their car. Ultimately, he pled down to something else. There was an incident of violence between the mother and the father in front of the child. Ultimately, the court grants custody to the father during the course of this case, and the court talks about the mother not allowing him visitation. And I think, again, we go back to the transcript, and if you examine the transcript closely, you'll see they'll talk about the mother's non-compliance with common grounds. Okay? And there was a Chris Derry who testified from common grounds who actually says, well, the days changed multiple times. There's reference in the actual transcript that says the order that the parties were supposed to go to common ground. There was never any date in that order. There was never any time. But yet the mother is constantly blamed for not being the person to bring the child to common ground. If you examine Chris Derry's testimony very carefully, you'll see that he was getting mixed messages about the time from both parties. Not just the mother, and I'm sure counsel will say it was the mother, not bringing the child, not bringing the child. But the actual transcript, Chris Derry testified he was getting mixed messages from both parents. Now, and also plays into my second issue where I talk about the guardian ad litem. If you examine the guardian ad litem's report, you'll see that a substantial amount of his time was spent with talking to the father's counsel and the father. It's like a half an hour devoted to talking to the mother. The guardian ad litem never talked to any of the witnesses that actually appeared at trial. None of the child's caretakers. When the guardian ad litem was asked about talking to the child's doctor, he said he reviewed his website. And that also plays into my other two issues because the father was constantly floating allegations that the mother was drugging the child. And the transcript, the pediatrician actually talks about this medicine that she prescribed for the child. There was allegations at common ground that the mother was giving the child hallucinogenic, which was absolutely untrue. The guardian was going around based on the word of the father's counsel that the mother had fled the country to Poland. Never happened, completely untrue. Of course, that was there. All of this was supposed to be her non-compliance. And the reality of the matter is In this case, and I'm going back to the actual change of custody again, I know I'm mixing issues, but I think they all kind of played together and ultimately the final judgment here. The final judgment, the trial court awards the father, makes the father a residential parent, removing the child from the mother's home, where he had grown up, always been in the same place. Even when they were married, the mother was the primary caretaker. Now, when we look at the factors cited in that statute, talking about allocation of parental rights, the ultimate factor that any court is supposed to look at is the best interest of the child. Okay? Now, here's a father who had prior documented examples of being abusive towards females. I understand that he wasn't actually convicted of burglary. Those factors, that charge was there, those facts were there, and ultimately he pleaded it down to criminal penalty. Same thing, domestic violence, assault protection order that he violated multiple times. Then you have the fact, the record shows he had suicidal incidents, major depression. His best friend testified about him coming to his home talking about suicide. The clearest example why this court should overrule the trial court granted the father residential parent. During that, after the notice of appeal was filed, 3 motions to stay were filed to stay the final judgment. Attached to each of those motions were 3 separate documented incidents with a child in the course of 4 to 6 weeks was pictures documenting the child had been injured on 3 separate occasions in 6 weeks. Now, I realize that doesn't rise to the level of abuse. If you look at that, plus the other 2 incidents that occurred prior to trial, it certainly shows a lack of supervision of a very young child. There is no evidence in the records whatsoever that the mother ever abused the child, that she was a bad mother, or she did not take care of the physical and mental health of this child. Based on that, I believe that the court should, after looking at the transcript and examining the actual evidence, and I understand the child court played a certain amount of lip service to the factors that he should consider. Ultimately, in this case, the record shows, the transcript shows, that it was in the child's best interest to remain with the mother. Unless you have any questions, that's all I have.
I have a question regarding the incident, and I didn't see very much of, well, you did reference it in your brief, but didn't go into a lot of detail about this October, I want to say it's October 25th hearing before the court, or maybe the hearing was before that date, but the court said, on this date, I want the child turned over from mother to father. And the
order, October 25th was an order. There was no hearing on that.
Okay.
Basically what happened
Well, the court says that the counsel, or the brief said that counsel were there, and the court said, this is what is to happen, and it's to happen on this date.
Oh, okay. Let me be clear, because the dates, I think in the transcript, are somewhat confusing. There was the court's talking about I think it was a pretrial in chambers, and I think in the father's brief he said all the parties agreed. Well, the parties weren't there. It was the 2 lawyers and the guardian ad litem, and that's not in the record. It was in Judge Quinn's chambers.
Well, there's a reference to the transcript.
Okay, well, I'm getting that part.
Okay.
So this initially happens in chambers, where Judge Quinn essentially says this is what's going to happen. Okay, that was never reflected in a written order. Okay, and I'm not sure about the date, but that might have been a Wednesday or a Thursday, and that Saturday is when, if I'm not mistaken, that was the October 25th, when the guardian at Lyden goes to mom's house. And she, if that, am I referring to, we're talking about the same?
Yes.
She asked him for a written order, and that's what we're there. And during the hearing, is that what we're referring to? That those, and there's testimony about that, where he comes out to the house and she knows that there's still a valid civil protection order in effect. And father's there in the parking lot, and she explains that she got afraid, and to be honest with you, I can't remember exactly the testimony, but I remember the sequence of events. And basically, what I'm trying to clarify is this alleged order took place in chambers that was never journalized, and that hearing, that order that's referred to in the transcript was never journalized at all, even to this day. And then we go to start the trial, and there's testimony about those chain of events after that pretrial, and that's what Judge Quinn
referenced in as the to the transcript.
That's what's referenced in the transcript,
okay,
but there's no actual written order.
Okay.
That's why there's that confusion there.
Thank
and
you.
Then the judge changes the order at that point where there's like a visitation.
Okay.
Thank you, counsel, for your presentation this morning.
Thank you, Your Honor.
Good morning. May it please the court, my name is Bruce Malziner. I represent Nicholas Roth, the FLE, father, husband in this unfortunate matter of domestic relations and the placement of the minor child with one or the other of the parents. On January 27th, Judge Quinn filed his final entry, decree of divorce, from which the appellant files 3 errors that the court committed. The first one was the assignment of error for that the portion of 310904 was unconstitutional, and I think that the court has identified the major flaw in his argument in that he did not follow the dictates of 2721.12 that require it to be served upon the Attorney General in matters involving the constitutionality of a statute or failure of due process. Further, even if that weren't the argument, the court in 310904 has a laundry list of items in which it should or shall go through in determining the rights and responsibility of the parents. And it's clear if you read the judgment entry of divorce that the court painstakingly went through each section of 310904 and responded to it in each and every section, including the facts that the appellant has failed to comply with court orders and is not likely to follow court orders, and that seems to feel that her decision as to what is necessary to follow are her dictates rather than a court's. Just to clarify for a moment this October 20th, 25th issue where the wife did not turn over the child. The pretrial was held in chambers of Judge Quinn, in which he very pointedly indicated that this type of taking the opportunity for the father to be with his child was no longer going to be continued or acceptable, and ordered that starting on Saturday the 25th at 10 o'clock till 4 o'clock that day, my client, the appellant, Nicholas Roth, would have unsupervised visitation during that period of time. It was also determined that the GAL, because of the contentiousness between the parties in previous instances, would serve as a go-between to help obtain the child from mom at her door, along with the grandfather of my client, or the father of my client, who was the grandfather of Miko, the child, who at that time was roughly 2 years old. Mr. Roth and the GAL showed up. Mr. Roth, being the grandfather, showed up at the door and as indicated by appellant's counsel, demanded to see a written order, and then refused to allow the child to go with the GAL and the grandfather. And her sister called the police, and 3 squad cars swooped in into the area and talked to all parties and determined that she didn't want him to go, we're not going to have a problem here, and advised my clients to leave. On the 27th of October, 2 days later, the guardian ad litem filed a motion with the court, the trial court, suggesting that based on the appellant's actions and not allowing this to take place, and it was clearly understood between all the attorneys at that hearing, that there was he suggested a change of the temporary custody, to which the court approved, agreed. And interestingly, Your Honor, on that very day that the GAL was in the court filing his motion, Ms. Chlebowski left her employment, took off, left no forwarding address, advised her employer that she was taking a week off, and testified at trial that she took off and stayed overnight with friends and did a lot of praying and never contacted anyone. Yes, my client was concerned that because his wife and her father were both citizens of Poland, that based on the turn of events that they might have taken off to leave the country with the minor child. And yes, they did question the GAL to help find out where she was, and he never did. The counsel for the appellant would have argued in the trial court that she didn't know about the order, and yet the court abused him of that knowledge, because lack of knowledge, by saying, counsel, when you know about it, your client knows about it. And the GAL had testified that he had, on the date of the motion being granted on the 27th of October, that he had emailed and faxed a copy over to appellant's counsel. So clearly, she was not playing ball, she was not following this court's dictates, and my client did not get to see the child for an additional period of time. Now, we go back, and from January of 2014 until December of 2014, my client was not allowed to see his child because appellant refused to deal with Common Grounds, who had testified and written a report to the court as to what they had observed as her indiscretions with respect to the child during the visitations at Common Grounds facility. From February 14th, when the GAL was appointed, until June of 2014, there were only 5 visitations scheduled that were agreeable to the appellant, and of the 5, 2 of them were missed, for which she refused to pay for missing them, and that was testified as to court. Importantly, on the main issue, on January 20th, which was the last visitation, Chris Deary and the father found a hidden tape recorder, miniature, in the child's shoe, between his foot and the shoe, which was painful, and he was fussing and in some pain, and they took his shoe off to find out why, and they found this little recorder in the on position. Mr. Deary showed that and brought it to the court, and showed it to the court, and it was really miniature, and it was under the child's shoe. They also found, sewn into the diaper bag, another recorder, which was on, which mother in court testified that yes, she did put it in the bag, and yes, she had listened to it, and the reason was she wanted to know what was going on in these meetings, so she surreptitiously provided. She had not advised Mr. Deary, or the GAL or anybody what she was doing. The GAL spent considerable time trying to unravel the visitation issue between the parties, and it became apparent to him that the main issue was the fact that wife did not want to participate in visitations whatsoever in allowing the father to have visitation and time with his child.
Counsel, what are we going to find in the record? I mean, it sounds like there's enough trouble, you know, on both sides, but what are we going to find in the record that the trial court considered, as Mr. Colvin raised, issues regarding father's suicidal ideation, his alcohol consumption, and these documented aspects of violence against women? What are we going to find that assures us that the trial court considered and took that into consideration?
Well, the trial court heard evidence, obviously, from the gentleman who testified on behalf of the wife with regards to this conversation involving supposedly suicide thoughts of my client, which my client said not true. And he was not a friend of this gentleman. He had known them several years earlier and had gone to his house, was depressed over the fact that he and his wife were having marital difficulties, and there was incidences where he was not permitted to see his child.
So
and that was depressing to him.
Did he deny that he had discussed suicide?
Yes, he did. Yes, he did.
What about these charges that I guess were reduced about, I can't remember if it was...
You asked about alcohol consumption.
Yes. Mm-hmm.
And other than the fact that it was mentioned in one instance with regards to, I believe, the incident regarding the burglary situation, the parties had been out drinking. Apparently these people were being obnoxious, and my client made an inappropriate scenario to quiet them down, and it escalated to the point where, yes, he did misbehave, and that was testified to. And, you know, the court heard that. It wasn't kept out. It wasn't, you know, objected to. It was part of the record. So, but, you know, as far as drinking, there were no other allegations of drinking other than in that one particular instance that I'm aware of.
I just didn't recall from reviewing the court's entry that there was any discussion of that.
Mr. Colvin, I believe, entered into that discussion in his cross-examination or examination of his client, as well as a conversation with my client on cross-examination. The best interest of the child is always a consideration for the court. It's the primary concern of any trial court, and they being in the best position to observe the actions and gestures of the witnesses and the documents as they're presented. The facial expressions and gestures are generally given great credence by a reviewing court, and unless they find an abuse of discretion, which I believe will not be found in the record or anything that has been presented before this court, that Judge Quinn abused his discretion and that his findings were anything but in accordance with the terms of 310904. And accordingly, we would ask this court to affirm the judgment of the trial court in its entirety and to order it into effect immediately so that my client can enjoy the time with his child. Thank you, Your Honor.
Thank you both for your presentations this morning. The court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as posted on the Ohio Supreme Court website which can be linked to through the 9th District website. Thank you.
Thank you, Your Honor.